Welcome to Synergy Settlement Services webinar on medical cost projections and Medicare set-asides, two sides of the same coin. My name is Rasa Fumagalli. I'm an attorney and the Director of Medicare Compliance here at Synergy Settlement Services. Before joining Synergy, I spent over 20 years as a Chicago-based insurance defense workers' comp attorney. In 2009, I began specializing in MSP compliance issues and have devoted my practice since then to helping parties address Medicare's potential interest in their personal injury, no-fault, or workers' compensation settlements. Attorneys often wonder if they need to put aside the amount of the future medical identified in a medical cost projection or life care plan from the settlement in order to avoid a cost shift of those expenses to Medicare. Although medical cost projections and Medicare set-asides both provide estimates of the future injury-related care, they serve different purposes in a case. This presentation is going to take a look at these issues. Let's begin with the medical cost projection. It is a report that is usually prepared by a nurse allocator who may or may not be a certified life care planner. The report projects future injury-related care, medications, and related expenses such as mileage to and from medical appointments. It projects for conditions that the attorney is alleging are related to the accident or exposure. It is something that can also be prepared before causation opinions and depositions are taken. The projections do not distinguish or differentiate services or drugs that are Medicare covered and those that are not. Medicare really doesn't play a role at all when you are estimating the future injury-related care. The individual's Medicare status is irrelevant for this medical cost projection. People are going to use the medical cost projection to either provide support for their initial settlement demand in the case, or they're going to use it to help bridge the gap between the initial defense offer and the demand that is being made in the case. This slide shows examples of some of the results that attorneys were able to obtain using Synergy's medical cost projection. As you can see, the medical cost projection was used in a California auto accident case. The initial offer was $30,000. Once the medical cost projection was obtained and negotiations continued, the case was able to settle for $70,000, which is basically a $40,000 gross offer increase. Medical cost projection was also used in an Alabama motorcycle accident case where the initial offer was $900,000. After the medical cost projection, the offer was increased to $1,050,000 for a gross offer increase of $150,000. Another example is a Georgia medical malpractice case. The pre-medical cost projection offer was $1 million. Post-medical cost projection offer increased to $2.1 million, gross offer increase of $1.1 million. The medical cost projection is a nice way to get the defense to sit up and pay attention to your demand. Another question that pops up involves the differences between a medical cost projection and a life care plan. They both provide future medical costs, and they both are used to bill damages. The differences, though, are that medical cost projections are usually used for settlement negotiations and mediation, while a life care plan may be used when you expect the case to go to trial. Medical cost projections are based on information that you, the attorney, provide and the medical records that you provide. On the other hand, a life care plan will generally involve discussions with the injury victim, along with discussions with the treating physicians. This is the reason why life care plans may take months to generate. The cost of the medical cost projection is also significantly lower than the cost associated with the life care plan, making it more appropriate for many cases. So how does Medicare play into any of this? To answer this question, we have to take a look at the Medicare Secondary Payer Act. For those of you who may be new to this space, Medicare is the federal health insurance program that is available for certain individuals who pay into the system. You become eligible for Medicare by virtue of age when you are 65 years or older. Certain younger people with disabilities that are awarded Social Security disability benefits will also become eligible for Medicare after a waiting period has expired. People with end-stage renal disease, permanent kidney failure, which requires dialysis or transplant, are also eligible for Medicare benefits. Although Medicare used to pay for any treatment that a Medicare beneficiary ever needed, the Medicare Trust Fund started to deplete a little bit too quickly. There were a variety of reasons that caused this. People were living longer, you had medical advances, yet people were still eligible to collect Medicare benefits when they hit 65. In order to shore up the financial integrity of the Medicare Trust Fund, the Medicare Secondary Payer Act was created in the 1980s. And what the law basically says is that Medicare is a payer of last resort or a secondary payer when payment has been made or can reasonably be expected to be made under a workman's compensation law or plan of the United States or state, or under an automobile or liability insurance policy or plan, or under no-fault insurance. Medicare regulations further state that Medicare is precluded from making payment for services to the extent that payment has been made or can reasonably be expected to be made under workers' compensation, liability, or no-fault insurance. The exception to this is that when Medicare has a beneficiary where payment is not being made by the responsible party or the insurance carrier, and it's not expected to be made within 120 days of receipt of the claim, Medicare is willing to make payment in that situation on the condition that the Medicare Trust Fund is reimbursed for the payment when a settlement agreement is reached. Now, when I am talking about Medicare, I am not only talking about Medicare Part A and Part B, which is traditional Medicare, but this right of recovery also includes and pertains to Medicare Part C plans with our Medicare Advantage plans and Medicare Part D plans, which are the prescription drug plans. At this time, there is limited guidance in how to address Medicare's interest in regard to post-settlement, future injury-related care. Medicare has taken a few stabs at trying to pass a rule. The most recent attempt began in December of 2018 and was subsequently withdrawn in October of 2022. The language in the proposed rule, however, stated that it was intended to clarify existing Medicare secondary payer obligations associated with future medical items, services related to liability insurance, no-fault insurance, and workers' compensation settlements, judgments, awards, or other payments. And the proposed rule would also remove obsolete regulation. So what are you supposed to do in terms of Medicare's potential interest in a settlement? It's important to understand that there are three main components to Medicare secondary payer compliance. The first is that you have to address Medicare's interest in reimbursing or negotiating payments that were made for the injuries prior to settlement. Those are conditional payments. Whenever a settlement takes place with a Medicare beneficiary, there's going to be mandatory insurer reporting that is done under Section 111. When the reporting is done, Medicare is going to be able to recover payments that were made prior to settlement. They're also going to be able to avoid making future payments for conditions that were compensated in the settlement. So you have to think past payments, conditional payments, you have to think mandatory insurer reporting, and you have to think about avoiding a cost shift of post-settlement injury-related expenses to Medicare in certain settlements. In order to avoid having issues with the Medicare Secondary Payer Act, there are certain factors that you should consider when you are representing an injury victim. Obviously, the first factor is your client a current Medicare beneficiary? If not, do they have a reasonable likelihood of Medicare entitlement within 30 months of settlement? To figure that out, you should take a look at their age. Are they 62 and a half? Have they applied for Social Security disability benefits? You also should take a look at the nature of the injury. Is it one that is likely to require ongoing injury-related care? You need to consider if you have a settlement, if the settlement is funding future medical. And you also have to take a look at the injury victim and the firm's risk tolerance. What exactly is the risk when we're talking about a failure to address Medicare secondary payer compliance issues for future medical? Let's take a look at a case study. We had a situation where there was an $80,000 settlement. The settlement involved an injury to the shoulder. The settlement was reported by the defense under mandatory insurer reporting. Nothing had been done by the injury victim or counsel regarding post-settlement injury-related care. When the injury victim went for treatment for that shoulder injury post-settlement, Medicare denied payment of the services. The injury victim, of course, went to the attorney upset about this development. This is what the letter looked like that the injury victim had received. It basically had a denial. Did Medicare approve all services? No. And if you look at the next page, the reason for this was that your claim had been denied by Medicare because you may have funds set aside from your settlement to pay for your future medical expenses and prescription drug treatment related to your injury. Now, this does not necessarily mean that there should have been a Medicare set-aside. This might have been a situation where the policy limits were such that the settlement was simply insufficient to fund future medical. The point is that there needs to be a discussion with the injury victim about Medicare's potential interest. So the way to do this is, if you are not familiar with various Medicare secondary payer compliance options when it comes to addressing futures in a settlement, whenever you have somebody who's eligible for Medicare, future accident-related care is a possibility, and the case has a claim for future medical, we recommend that you consult with experts. You advise your client of the potential Medicare secondary payer implications, and you secure proper documentation for your file so that you do not have a situation where the injury victim comes to you post-settlement with care being denied. When a settlement does involve an injury that will likely result in future injury-related care, the key is to avoid cost shifting these expenses to Medicare. And there are ways to do it other than a Medicare set-aside. If the injury victim has other non-Medicare health insurance available for this accident-related care, they can certainly put the treatment through that insurance. They can also simply choose to pay out of pocket as they go for injury-related treatment. A medical savings account can be set up in certain situations, or a settlement preservation trust. An annuity may also be purchased from the settlement for future injury-related care. A Medicare set-aside is also an appropriate way to avoid cost-shifting post-settlement future injury-related care to Medicare. There's no requirement under the Medicare Secondary Payer Act for the Medicare set-aside. It's simply a settlement tool that allows you to apportion settlement proceeds and earmark them for future injury-related Medicare-covered treatment. Medicare Set-Aside report is prepared by nurse allocators, or you can also have a certified life care planner prepare a Medicare Set-Aside. The report includes projections in the liability settlement space for injury-related treatment that is reasonably likely to occur in the future that is covered by Medicare. Now, when you're negotiating a settlement, of course, there may be services that are not Medicare covered that you would include in your demand, and that medical cost projection is a report that lists everything that is needed. The Medicare set-aside also includes Medicare covered drugs. Not all drugs are covered by Medicare. For example, Medicare covers drugs that are FDA approved for the purpose for which they're being prescribed. Medicare also covers drugs that are off-label compendia approved for the purpose that the drug is being prescribed. Liability Medicare set-asides are priced at the usual and customary charges for the services in the area where the individual resides. On the other hand, workers' compensation Medicare set-asides are priced based on the state's workers' comp medical fee schedule, if they have one. Liability MSA drugs are priced out at retail cost. Unlike a medical cost projection, the liability Medicare set-aside is typically based on a rated age quote, which results oftentimes in a reduced life expectancy from a standard life expectancy. A liability MSA does not project treatment that might possibly occur. Rather, it projects treatment that is reasonably likely to occur. When you have a liability case, there are many different buckets of damages that you are looking to obtain compensation for. This is different than the more limited damages that are available in a workers' compensation case. A liability settlement is going to have a component of economic damages, non-economic damages, as well as medical. Because of this, it doesn't make sense to fully fund a Medicare set-aside. A reduction analysis is an appropriate way to address how much of that net settlement should be earmarked for future injury-related Medicare-covered treatment. The reduction analysis begins with a Medicare set-aside report that fully funds all of the future injury-related Medicare-covered treatment and medications that are reasonably likely to occur. Once you have that number, we look at the ratio between the total potential case value and the net settlement. We apply that percentage to the Medicare set-aside amount to come up with the number that objectively determines the portion of recovery that should be earmarked for future medical. Once these funds are properly exhausted, then Medicare should become the primary payer for any additional injury-related treatment. So what are the differences and how do you reconcile the medical cost projection with a Medicare set-aside? A medical cost projection is intended to help you bill damages to maximize the settlement. You are including treatment that might occur based on the injuries that you're alleging. It doesn't matter if it's Medicare covered or not Medicare covered. You are seeking to compensate your client for any possible expenses that they may be stuck with because of these injuries that they suffered. A Medicare Set-Aside, on the other hand, looks to the parameters of the settlement, and the purpose is to identify how much of that settlement should be earmarked for future medical in order to avoid a cost shift of post-settlement injury-related care to Medicare. Here's a slide of the various services that Synergy offers. We do offer medical cost projections, Medicare secondary payer compliance, healthcare lien resolution, attorney fee deferral, settlement consulting, group projects, and consulting on government benefit preservation. Thank you for your attention. If you have any questions, please feel free to reach out to me. Rasa Fumagalli, Fumagalli, @ synergysettlements.com.